Have you received an eviction letter? Your landlord may give you, their tenant, a notice in writing that they want you to move out of the unit. This notice is called a notice of termination. Landlords must use the proper form under the Landlord and Tenant Board for a reason allowed by the Residential Tenancies Act. The notice period depends on the type of notice and reason for eviction. The notice must be properly served to you, the tenant. This can be done so by handing the notice in person, by courier, by mail, or by email, depending on the situation. The notice of termination will indicate a termination date, but you, the tenant, are not obligated to move out yet. The notice simply indicates the date the landlord wants you out by. But if you disagree with the reasons for eviction, you don't have to move out by this date. You can wait for the board to hold the hearing. Except for in the case of rent arrears, your landlord must file the eviction application no later than 30 days after the termination date. Once the application is filed, the board sends a notice of hearing and additional instructions to all parties. These instructions may include disclosure requirements and where to get legal help. At the Landlord and Tenant Board hearing, there will be an opportunity for all parties to explain their views of the issues, present evidence, or request specific remedies from the board. After the hearing is finished, the Landlord and Tenant Board will make a decision. If the Landlord and Tenant Board decides that your landlord does not have a legal reason to evict you, the order will say that the landlord's application is dismissed. This means you do not have to move out. If the Landlord and Tenant Board decides that there is a legal reason to evict you, you will receive an eviction order. The order will say that the tenancy is terminated. In this case, the order will indicate the date the tenancy is terminated and when the Landlord and Tenant Board is authorized to enforce the eviction order. It is important that you make prompt moving arrangements because you may receive a removal notice from the sheriff at any time. A normal order usually allows the landlord to have the sheriff enforce the order 11 days after the date of the order. Enforcement is done through the sheriff's office, sometimes with police assistance. The sheriff's office will send a removal or enforcement notice to the rental unit, addressed to you, the tenant, with the date and time the locks will be changed. The landlord cannot change the locks. Only the sheriff can change the locks. After the sheriff's eviction, you will receive 72 hours to retrieve your belongings left in the unit. You as a tenant are responsible for contacting your former landlord and making proper arrangements. Your landlord must make the property available between 8 a.m. and 8 p.m. during the 72-hour period. For more information about your housing rights, visit www.WRCLS.ca. You can also contact Waterloo Region Community Legal Services at www.wrcls.ca/web-contact. Or you can give us a call at 519-743-0254. Check out our YouTube channel for more videos.